Good morning, Your Honour. For the record, my name is Bold Initial J and I appear for the defendant, Mr Wishbone, in this matter. Mr Wishbone is a juvenile defendant who has been charged with 106 counts of break and enter. Mr Wishbone is pleading not guilty to each count. On the last occasion, counsel for the defendant respectfully requested that the matter be set down for a 590 AA argument. Your Honour, today the defendant seeks a ruling in relation to the admissibility of the police statement and subsequent record of interview pursuant to section 590 AA, subsection 2E. The defendant intends to outline to the court that it should exercise its discretion to exclude the police statement and record of interview on the grounds that, firstly, the defendant was threatened by police, therefore the confessions were induced. The defendant was not appropriately cautioned by police, therefore the confessions were improperly obtained. And lastly, the defendant would be unfairly prejudiced by their reception into evidence. In relation to being threatened, Section 10 of the Criminal Law Amendment Act provides that a confession should not be admitted as evidence in a criminal proceeding where it has been induced by a threat by a person in authority, and every confession made after that threat shall be deemed to have been induced unless the contrary can be shown. The defendant submits that he was threatened by police and had no other option but to say he committed the offences. The first threat that the defendant experienced was when one officer took him by the shoulder, held him and then threw his backpack to the ground. The first confession that followed this threat was when the officer asked him if the possessions were his. Then, as they drove the defendant around asking him of other locations he allegedly broke into, and lastly the confessions that were obtained in the record of interview. The support person chosen for him by police also told him to make sure that he answered the questions police asked of him. This inferred that there was a consequence for not doing so. When considering this as a whole, the court should take into account the defendant's age and the power differences. The defendant contends that any admissions he made were induced by threats and therefore should be excluded from the evidence. In relation to not being cautioned, Section 431 of the Police Powers and Responsibilities Act requires police to caution a relevant person as to their right to silence in the way required by Section 26, Schedule 9 of the Police Powers and Responsibilities Regulations. A relevant person is defined in Section 415 of the Act, and it applies to any person who is in the company of a police officer as a suspect for being questioned for their involvement in an indictable offence. Section 26 requires police to state to the relevant person that before they ask any questions that they have the right to remain silent. The interviews that occurred on the 23rd of June 2016 and occurred on 3 separate occasions. On the first occasion, the defendant was questioned at the address where he was located. Immediately after this, he was questioned as police drove him around in the unmarked car, and the last occasion occurred at the police station. The defendant was not cautioned on any of these occasions. The defendant submits that if he had received the appropriate caution, he would have exercised his right to silence because of his age as a juvenile, and that he was without a support person. But most importantly and most significantly is because of the cultural differences, as the defendant identifies as Torres Strait Islander and his people have an inherent distrust of police and authority figures because of past social injustices. The R versus Ireland discretion was adopted in Bunning versus Cross. The court held that evidence can be excluded on public policy grounds when police improperly obtains evidence through lack of compliance with procedures as laid out by statute. As already indicated, the evidence was improperly obtained as police breached the statutory provisions already outlined. In this situation, there were no valid reasons for police not complying with the legislation, as there was ample time and opportunity to caution the defendant. Finally, the defendant submits that the court has both a statutory and a common law power, or basis rather, to exclude evidence on the basis that it was unfairly obtained. The statutory basis to exclude evidence on the basis of fairness is contained in Section 130 of the Evidence Act, which confers power on the court to exclude evidence in criminal proceedings if it would be unfair to the person who's been charged. The common law basis is known as the Christie discretion. Justice Thomas in R versus Hasler provided the test for the exercise of the discretion, which can only occur when the prejudicial effect outweighs or substantially outweighs whatever probative value it may have, and where there is discreditable conduct which doesn't go directly to defence. The case of R versus Rogan and Jones held that Section 130 preserves the discretionary principles exercised by Justice Thomas. The defendant submits that the evidence has little probative value due to the unreliability of the evidence given the circumstances as a whole. Your Honour, the discreditable conduct is a conduct by police towards the defendant due to their blatant disregard to his age, culture and rights, and for police procedure overall. There have been situations where the court has applied both discretions, such as in cases like Foster versus the Queen and R versus Stewart. Therefore, it's open to the court to apply both discretionary grounds. Your Honour, the defendant respectfully submits that it's within the court's power to exclude the evidence based on police obtaining the confessions by threats. Therefore, they were induced. The defendant wasn't properly cautioned, therefore they were improperly obtained, and the reception would be unfair. If Your Honour is not minded to exclude the evidence based on the arguments put forward today, the defendant seeks a direction to the jury in accordance with McKinney versus the Queen, in which the jury should be directed to give careful consideration before accepting the confession without some corroboration of the fact that it was made. This is already based on the defendant saying that the confessions were made without substance. Thank you.